Showing on this episode of Law Weekly some reactions trailing the Supreme Court judgment that the federal government should commence payments of allocations directly to local government councils from the Federation account. We have the reactions of two senior lawyers, Senior Advocate of Nigeria, Olukayode Enitan, and President of the African Bar Association, Hannibal Uwaifu. We'll get to that reaction in a bit, but also showing on the program, the Economic and Financial Crimes Commission has held rallies across the country in commemoration of the African Union Anti-Corruption Day, with a charge to Nigerians to willingly embrace the whistleblowing policy of the federal government. It was our recap of the top trending stories in the courtrooms. Hello and welcome to the program. I'm Shola Shuyeli. Reactions have not stopped trailing the Supreme Court judgment on local government autonomy, which has finally laid to rest a long controversy trailing the funds of this third arm of government. Many people have continued to hail the judgment, and on the program today we have the views of two senior lawyers on the judgment.
Well, the judgment is being long awaited, and I believe the federal government had, in the course of the years, tried to achieve that purpose through different means. But this is the one that no one can run away from, because this is a judgment of the Supreme Court which is binding on all the states. So the judgment is in good standing, it is well done, it is kudos to the Supreme Court as a policy court. They've done that which is necessary and in compliance with the Constitution of Nigeria. What it means basically is that the attitude of most of the governors have now been put in check. And what is this attitude? It's simply that they use the local government money as they will, as if it belongs to the state, but it doesn't. So now, with this judgment, money goes directly to the local government coffers. The local government is now responsible for utilizing the money. So what are we going to see? Local government definitely have to do budgets. Now, local governments, because they are also closer to the people, it's easier to ensure everyone will know what monies got to the local government. It's published, I think, monthly or thereabouts. Once it is published, you know where your local government chairman is. You know the local government headquarters. So they can be held to account. And the excuses which had always resounded in the past, this is how much we are given, we do not have anything, the state government is doing it, or is supposed to do it, all those excuses disappears. The local government receives the money. The local government is expected to expend the money to do the things that the local government is constitutionally empowered to do. And every excuses should disappear. The governors themselves, of course, they can begin to think up other ways, but every one of such ways would be in direct conflict with this judgment of the Supreme Court. So monies would move from the Federation account now to the local government account, not joint state local government account, but an account in the name of the local government, which is then utilized for activities within that local government. Not that you're going to borrow from one place to the other. Now, the other implication is in those states that have local government development areas. Now, you know, in bringing governance closer to the grassroots, some of the states created local government development areas. Those ones are now, because before, when the allocation is received, the governor now disburses it. For instance, Kosofe local government has a sherry under it, a sherry, Ikosi sherry was carved out. Ketu Agboyi or something like that was also carved out of Kosofe. But now, all the money will go to Kosofe local government, using that as an example. It is now the duly elected chairman and councillors that will now determine how that money gets disbursed based on whatever budget they have done. Now, that may create some challenge in the sense that those LCDs will now not have any money coming to them from federal government allocation, at least legally. However, the state governors would know what to do to ensure that those areas gets taken care of. The other aspect of that is that because those LCDAs, the territory comprised in each LCDA is still subsumed in the local government constitutionally recognized, development will still get there. So what's going to happen, in my view, is that if there is a caretaker committee in any specific local government, there will be no disbursement. Because where there are no elected representatives, who is the money going to? This money is supposed to go to that local government to be disbursed according to law. Now, it will be illegal to then send money to a local government to be disbursed or expended by someone who was not elected, who was appointed. So all of that pales and disappears. And what I would expect those governors who presently have local, what do they call them, caretaker committees, is that within this month and next month, you will find out that elections to local government councils will be held. And of course, once elections are held, those who are duly elected will receive the money. And fortunately, the fund is coming from the federation account. So whether you like or you do not like, money gets paid into the account of a local government that has elected representatives. Those who do not have, their money remains in compliance with the decision of the Supreme Court that that money cannot go to unelected places. So it's there until the right people to receive it. And then it's not as if someone is withholding. No, it is that there is nobody to receive.
Let me start by getting your reactions to the Supreme Court judgment on local government autonomy.
Well, for me, it's a welcome development. It's long been overdue because local governments, as the third tier of government recognized by the Constitution, used to perform very serious roles and economic, political, social development for the country. But since this set of governors took over, I would say more than about, from about 2013, especially after the military handover, things fell apart. And there was no longer anything to hear about the local government. And there are a lot of reasons for that. One of the reasons is the joint account. It created a lot of problems. States and local government joint accounts created wealth for the state governors to use as their wish. And that was what led to the fall of democracy in local governments. Because the governors wanted the money, therefore they wanted to put whoever they want there. And because they're in charge of their states, they just felt, they could put anyone there and then subjugate them to their whims and caprices and utilize their funds the way they want. And so local government became powerless and became useless and ruthless, with all due respect.
What for you are the implications of that judgment on the government and even that third level of government?
The implication is that the local governments are back in place. And let me use the opportunity to commend the federal government for taking this bold step. I think it makes some sense. And then also the Attorney General of the Federation Minister for Justice for pursuing the case to its logical conclusion. We know, like in the country like this, there will be party talks, there will be talks of friendship, and all kinds of talks about, no, why don't we do it this way? But the government, federal government insisted on why did the federal government do that? I believe that the federal government also wants a situation where, most of these developmental agenda, that hangs in the air in between the federal government and the states rolls down, because local government, quite frankly, are very close to the people. And then the government, I think, became so worried that the local governments were not performing their statutory roles. So the implication now is the local governments are back as a democracy. One, you can't receive funds from the federal allocation, from the joint allocation from the federal government without a democratically elected government in the local government council areas. So caretaker committees, which hitherto have been an aberration, has been buried and buried for life. So local government elections will now have to be conducted as and when due. And that is why the crisis in Rivers became a little bit very funny, especially when the police was saying that they were expecting court judgment. What is court judgment? Local government tenure are tenure. They are there. They are specific. They are specified, like the states, like the local, like the presidents. The presidency. They are all specified, and as such, you cannot extend the tenure of local government. When it's time to conduct elections, elections are conducted. Local governments are tenured. They are elected by the people, just like the governors and the president. So their tenures can be extended for any reason. And so the Supreme Court must be commended for taking, additionally, apart from the funding, the Supreme Court was also specific that local government elections must be conducted, and that there's only elected council chairmen or council local government areas that are entitled to those allocations. So the controversy in Obasanjo regimes about the creation of LCDAs in Lagos has been buried. It is only local government recognized by the Constitution and have elected officials that will be entitled to that allocation.
Not LCDAs.
The LCDAs are not entitled to those allocations. It has been held before, even by the same Supreme Court, that states are free to create as many local governments as they want, but the only federal government will only fund the one accorded recognition by the Constitution. Those 774 local government areas, those are the ones that were saying. So states should not be bothered or scared about creating local government. It's their responsibility to do so. If you want to create one local government, you can go ahead and do so. But the state will have to be the one to fund it. But the ones the federal government will fund is the one that is recognized by the Constitution. Zumno is talking about democratically elected government, and therefore, if the state wants to conduct elections, we must also from now hold them accountable. The State Independent Electoral Commission must conduct elections that are acceptable to the people of the local government areas, not puppets, not elections that are teleguided as is presently being done. And it's very shameful that we can continue in this way. Local government during the early 70s, early 80s, even up to the 90s, tar roads, build hospitals, take care of hospitals. But now they are those, they can't even pay their salaries. Where is the money? They are being stolen by state governments. They are being mismanaged by state governments because of this singular act of terrorizing local government chairmen and bringing their puppets in and there. And as a result too of the fact that most Nigerian politicians do not think about the reasons why they are elected. They only after what they are going to get. Everything is about politics, politics, politics. That's why Nigeria is stunted in growth in every area, particularly in every indices in this world. Nigeria's growth rate is stunted. So I thank the federal government of President Bola Tinubu for taking this initiative. But they must go further than this. They must send security operatives after this local government chairman, because the local government chairman who we presently are seeing all over the place are not the type of people that should govern local government. So local government must, the chairman and elections going forward must be based solely on programs. What program do you have? And then they must be held accountable. So Nigerian people must wake up. Not federal government have done their own. The Supreme have done their own. Now Nigerians must wake up to their own responsibilities of ensuring that this new freedom granted local government is safeguarded with all sense of responsibility and with jealousy.
What are your suggestions for implementing this judgment? Well,
I think that what we need to do now is there must be a lot of sensitization. And those who want to contest with local government appoint local government, those who want to contest local elections must be psychologically attuned to the fact that they are chief executives of their local government and that their powers are given to them by law, just like the governors and just like the president. And therefore, they must utilize it. And that connivance with any governor or government official is going to land them in jail, because we are not going to tolerate it. So they must start getting ready. That passing money, taking money from the federal government, for the local government, and for the people of that local government, and passing it on to state governors, is going to land them in prison. And as such, they must now psychologically attune themselves that they are going to receive money that they are going to use to develop. They are going to make budgets which are going to be presented before the councillors, which they are going to approve and which will be utilized in accordance with the budget. Anything short of that is going to bring their administration to disrepute, and it's going to land them in trouble.
Welcome back. The Economic and Financial Crimes Commission, EFCC, has held rallies across the country in commemoration of the African Union Anti-Corruption Day, with a charge to Nigerians to willingly embrace the whistleblowing policy of the federal government. Here's a report. The AU Anti-Corruption Day is marked annually on the 11th of July, and the day is set aside to enable member states to appraise their anti-corruption efforts and to also raise awareness on the need for fiscal responsibility. This year, the Economic and Financial Crimes Commission, EFCC, staged rallies across some major towns in Nigeria to mark the 2024 African Union Anti-Corruption Day. The theme for this year's day is Effective Whistleblowers Protection Mechanism, a critical tool in the fight against corruption. And the Commission is also encouraging whistleblowers to come forward, as they will be protected.
You are highly appreciated, but you must hustle if you want to.
As early as 7 a.m., officers of the Commission in Lagos, alongside invited critical stakeholders, filed out to engage in the work aimed at drawing attention to the importance of whistleblowing. The anti-corruption work kicked off from the EFCC's Lagos Zonal Command on Awolowo Road, Ikoyi, Lagos, through Kefi Street, Obalende, Igboshere, Tafawa Balewa Square, and back to the EFCC office. It was the same scenario in Kano, where officers of the Commission also took to the streets alongside critical stakeholders. In the Ilorin Zonal Office of the EFCC, the rally was graced by stakeholders, including a monarch.
All gentlemen of the press, and my my good friend,
the message from the acting zonal director of the Lagos Zonal Command of the EFCC, Michael Wetlas, and that of the zonal commander of the Ilorin branch, Harry Erim, was similar. They urged Nigerians to willingly embrace the whistleblowing policy of the federal government, saying it is one of the potent prevention strategies against corruption.
What you are seeing today is a walk against corruption. It's an African Union walk against corruption, a day they set aside specially for Africans to be conscientized of the ills of corruption and why, as a continent, we must work together to eradicate corruption. And therefore, it is not a fight for just the EFCC or the anti-corruption agencies. It's a fight for the press, a fight for the citizens of the country, and a fight for everybody if Nigeria must move forward. So it's a day that is specially set aside for this conscientization that the fight should be taken by the people themselves. Therefore, it's a call. Let us all come together, join our hands. Let us all be all hands on deck to ensure that we eradicate this for a greater Nigeria and for the sake of posterity and the generations to come.
The theme of the 2024 Anti-Corruption Day is Effective Whistleblowing for Corruption-Free Nigeria. Whistleblowers are anti-corruption promoters. Through their efforts, anti-corruption agencies are alerted about environmental compromises that should be investigated. The alert can come through verbal and non-verbal corridors. The Eagle Eye app is an established corruption reporting device that is generating intelligence the Commission can leverage on. I urge whistleblowers to key into this device. Mails can be sent, telephone calls can be made, and personal visits can be made to any EFCC directorate across the country to expose acts of shadiness around us. We also assure every whistleblower of protection. EFCC will never betray you.
And just before we go, a quick recap of some of the top stories we tracked at the courtrooms this week.
We begin with the reports that the Supreme Court has ruled that the federal government should commence payment of allocations directly to local government councils from the Federation account. Delivering judgment in the suit, a 7-member panel of justices held that state governments have continued to abuse their powers by retaining and using the funds meant for local government areas. The Apex Court also ordered the federal government to withhold allocations of local governments governed by unelected officials appointed by the governor. Justice Emmanuel Agim, who read the lead judgment, also said states are mandated to ensure that their local government councils are democratically elected and that governors cannot use their powers to dissolve democratically elected local government councils. From the Supreme Court, we move to the Court of Appeal, where a 3-man panel of the court sitting in Abuja and presided over by Justice Onyekachi Otse has affirmed the election of Mr. Usman Ododo as the governor of Kogi State. The court upheld the Kogi State Governorship Election Petition Tribunal verdict, which affirmed Mr. Ododo as the duly elected governor of Kogi State in the November 11, 2023 governorship election, after dismissing the appeal filed by the Social Democratic Party's candidate, Mr. Murtala Ajaka. The appellate court, while resolving all 4 grounds of appeal against the SDP and Mr. Ododo, declared that the destiny of the appeal is not in the cloud and therefore dismissed it without cost. From the Court of Appeal to the Federal High Court, where Justice James Omotosho has granted the former Minister of Power, Saleh Maman, bail to the tune of 10 billion naira and 2 sureties in like sum. He was arraigned before the court on a 12-count money laundering charge to the tune of 33 billion naira. While ruling on the bail application filed by Maman and also noting that the offense is a bailable one, Justice Omotosho held that the sureties must own properties in Abuja with minimum value rate of 750 million naira. The court held that the sureties must submit certified land documents to the court with a 3-year tax levy. The trial judge, however, held that in the alternative, the defendants can produce bank guarantee of the said amount. The court also held that the defendants shall submit his bank statements and international passports to the court's registrar. The bail conditions was granted to the defendant after his lawyer, Femi Ate, undertook that his client is not a flight risk and would continue to appear for trial until the case is determined. The EFCC lawyer did not oppose the bail application. Justice James Omotosho subsequently adjourned the case to September 25, 2024 for commencement of trial. In Kano, the State High Court has ruled that the trial of Dr. Abdullahi Ganduje, chairman of the All Progressives Congress, his wife Hafsat Umar, and others accused of bribery and misappropriation will continue even in their absence. The state government has filed an 8-count charge against the defendants, alleging bribery, misappropriation, and the diversion of public funds amounting to billions of naira. Justice Amina Adamu Aliyu dismissed the application for a bench warrant and entered a plea of not guilty on their behalf. The prosecution counsel highlighted that service had been effected on the defendants. He requested the court to enter a plea of not guilty for the absent defendants and urged for a bench warrant of arrest, emphasizing the importance of maintaining the court's authority. However, counsel for one of the respondents argued that service was not properly effected and questioned the court's jurisdiction over the charges. He urged the court to dismiss the prosecution's applications. Justice Adamu Aliyu has adjourned the case until October 23rd and 24th for the hearing of the preliminary objection and the main charge. And we round off with the report that the Community Court of Justice, ECOWAS, has ruled that the Federal Republic of Nigeria violated the human rights of 3 NSAS protesters. The court found Nigeria in breach of certain articles of the African Charter on Human and People's Rights, specifically on the right to life, security of person, freedom of expression, assembly, and association. The applicants, Obianuju Ude, Perpetua Kamsi, and Dabiri Adeyinka, alleged that these violations occurred during the peaceful protest at the Lekki toll gate in Lagos State on October 20th and 21st, 2020. The judge rapporteur, Justice Koroma Sengu, who delivered the judgment, said that the federal government must pay each applicant 2 million naira as compensation for the violations of their rights. He also said the federal government must adhere to its obligations under the African Charter on Human and People's Rights, investigate and prosecute its agents responsible for these violations, and report to the court within 6 months on the measures taken to implement this judgment.
And that's the program for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Shayeli. Thank you for watching, and see you next week.